The reforms in the judiciary were joined now by Ikechukwu Ikeji, who is also a legal practitioner. Thank you for coming on today.
Thank you so much, Chamberlain, for having me.
Well, we started talking about this today with Mr. John Oloide, and
Yes.
he did shed a lot more light on some of these matters. But, well, you're also a practitioner. Perhaps you should start by asking you, the reforms that is going on or that the CJN had put in place, is there any one that stands out maybe with respect to the criminal justice system?
I would not say directly standing out with regards to the criminal justice system, but I would say it tangents, if you like, it touches on the criminal justice system. For example, where we saw a judge who apparently decided to go for a slap on the wrist in giving a judgment of pension scam that the CJN ensured was brought to book. It borders on, it touches on the criminal justice system, how judges are expected to apply the criminal justice laws in cases before them. We saw how the judge mishandled the case, and he used the the weakest punishment, as it were, to conclude the case. And we saw how the CJN also stepped in to suspend him, and some other such cases. So, while we may not say that there is a direct intervention on the criminal justice system in terms of institutionalizing or procedural changes, actions against judges that misbehave touches on the effects eventually.
One wonders, I mean, these reforms that she has put in place,
Yes.
do you think that maybe when she leaves, we can say that those reforms will still stand the test of time?
No, I don't think so. I think that it would also depend on the incoming Chief
Why
Justice.
is that always the case?
Because of lack of structure, lack of institution. Now, if you tabulate the problems and you put indices against the problems in the judiciary, you will realize that most of them do not actually touch on personalities. They touch on the weak structure, on loopholes. For example, mode of appointment, funding, composition of the NJC, social relationships. Some of these things do not have direct personal implications. They are structural issues that, when taken care of, whoever comes in there would have no option than to toe the line.
You know, in
Yes.
addition to all of this, because there are so many cases that go to the courts,
Yes.
and it looks as if it's endless.
Yes.
It never gets done with. For instance, now look at that Senator Ndume's matter,
Yes.
Honorable Farouk Lawan,
Exactly.
Honorable Herman Himbe.
Exactly.
Yes, we know man is innocent until proven guilty by the court of law. So
Yes.
why is it so difficult for these cases to be over and done with, whether they're innocent or guilty? And then let's
see,
move on.
Yes, you see, in our judicial system, we carry the principle of fair hearing to sometimes ridiculous extents. You see, you are entitled to be given fair hearing, and in being given fair hearing, it also includes situations where you may make interlocutory applications. That is,
Stay of proceedings?
probably something like stay of proceedings. You know, such interlocutory applications that you are entitled as of right to be heard. And when such applications keep coming on, and probably a judge gets exasperated with the process and tries to stop your applications or tries to act against your applications, you will run back to the section 36 of the Constitution, touching on fair hearing. Now you are not being granted fair hearing. So I think that it is also necessary for us to look at some of those principles and constitutional or legal provisions that tend to highlight right to fair hearing, and see how we can tweak them somewhat to achieve our purposes. Stay of proceedings has shown over the years to be a very negative instrument to delay justice. You know, and we can speak a lot against that. Another Another principle that has also contributed immensely is the principle of locus standi. You come before a court for a clear case of rights breach or illegal action, and suddenly a principle of locus standi is thrown against you, and you have to fight that out first before you would even be heard.
In some cases, the matter may get to Supreme Court, then from there.
And you now revert back to the High Court.
The
and even when you come back to the High Court, several other fresh applications.
But in all of this,
yes.
some would say it's a game that the lawyers also play. They employ it. They advise their clients that this is what we can use, perhaps to buy time or frustrate judgment.
Yes, I agree with you. You see, a lot of us lawyers bring our personal attributes, personal characters, moral values into our practice of law, and that should not be. A person who believes in fraud, for example, and becomes a lawyer would practice his law fraudulently too. A person who believes in backstabbing, using backhand tactics to achieve his aims will also employ those tactics in his law practice. So when there is proper structure, when there are institutional changes that strictly touch on some of these situations, it will be difficult for personal characters to overwhelm those institutional changes.